And the matter before the court is State of Maine versus Heath DeMerchant. This is a rustic 24207. If counsel would be willing to identify yourselves by saying your names for the record together with the party you represent.
Kurt Peterson for the appellant, Heath DeMerchant.
Matthew Hunter for the State of Maine.
Thank you. We are being streamed live on the web. Can't see the picture so well anymore, but it looks like it's in focus.
It's good so far.
Okay. Counsel, if you are ready to proceed, Attorney Peterson, we'd be happy to hear your argument.
Thank you, Your Honor, and good afternoon. Your Honors, even when the evidence presented at trial is weak or the credibility of the evidence is questionable, and regardless of where the evidence...
Are those concessions?
No,
I see that the green light is on.
It is, Your Honor, Your Honor. What I was saying was even if all those things are apparent, the presence of sufficient evidence to generate an instruction on a legal defense is required to be given by the trial court.
Let me ask you this. It's your position that your client had competing harms, whether to assault his partner or let his partner assault somebody else, essentially. Was an instruction pursuant to Section 108 requested?
No, Your Honor. In reviewing the record, I asked myself that question. Why wasn't a different instruction requested for physical force in defense of another person? It wasn't made in the trial court below, but the competing harms instruction was preserved, and I still think that it has as much force as that.
Well, would an instruction pursuant to Section 108 have been generated? Was that generated in this case?
I would contend that it would be generated in this case, but I think the theory in this trial strategy by trial counsel in this case was geared towards a competing harms instruction, but they were never able to put on that.
But should we be using a competing harms instruction if what you're really arguing, correctly or not correctly, but nonetheless, on the facts, if what you're really arguing is physical force in defense of another, should we even think about going to a competing harms? Where, in other words, that's such a general concept in competing harms, and frankly, one that probably should be applied somewhat sparingly versus the specific defense generated under Section 108.
Your Honor, I believe this court should review the record in order to determine in the light most favorable to Mr. DeMerchant whether there was sufficient evidence to require that instruction. What I thought when looking at the trial records, perhaps trial counsel believed that with regard to the incident in the hallway, which wasn't as much, it didn't seem as much as though it was in defense of another person or Ms. DeMerchant, but it could have been to stop her from trespassing or to go into a dangerous situation where there were drugs involved. So my thought was that was the trial strategy, it's to cover both of these events.
Well then, if with regard to the second event, when they're outside and he holds her back, according to him, if we were to determine that the defense of using force in defense of another is not generated in this case, should that preclude, on that incident at least and on those facts, the use of competing harms?
No, Your Honor, because the imminence factor is still there. There was still a situation that Mr. DeMerchant was trying to avoid from happening. He was restraining Ms. DeMerchant.
So even if it's not appropriately, I'm just assuming that, appropriately justified in using a reasonable degree of non-deadly force upon another in order to defend a third person, one still could have a competing harms defense in those facts?
Your Honor, I've found I have no reason to believe that there's any law to suggest that can't be the defense theory. And that's what their theory was in the trial court below. But I do appreciate the court's question, and I agree that would be cleaner with regard to what happened out in the parking lot. But I think competing harms is still generated based on this record.
Would you agree that even viewing the evidence in the light most favorable to the party asserting the justification, there still has to be a quantum of evidence? The party can't simply say, well, I had to defend myself, or I had to make this tough decision. I made the tough decision, and it was the right one, they have to produce more than that, correct?
Correct, Your Honor.
And getting at the quantum of evidence here, obviously your client testified to the effect of, was it Tamika, with the person who had the card?
Tanika, Your Honor, yes.
Tanika was coming over with the card, presumably to give it back, but he had to restrain the victim because he needed to protect Tanika. But as we look at the end, that was his testimony. But looking at the other testimony, Kirk testifies that she saw, people struggling up there. Terrio testified that he saw your client reach for Melissa, saw her hands go up, and he was reaching for her throat. And DeLong testified that he saw your client grab her by the throat. And we had the officer testify that he observed injuries to the throat. So as your client is saying, well, the victim was kind of agitated because she wanted her credit card back and someone was bringing the credit card. And then the visual is of him pushing her back, lifting up her coat, strangling her, grabbing her by the throat. Couldn't the judge say that based upon that evidence, even viewed in the light most favorable to your client, that doesn't hit the quantum of evidence to key in the competing harms justification?
I don't agree, Your Honor. I think that's the jury's call. I think there was enough evidence here to generate the issue, and there was also evidence that Melissa stated that she was grabbed in the jacket, not consistent with the other witnesses that Your Honor just mentioned. Mr. DeMerchant testified that she was jumping up and down, and when Tanika kind of comes around this corner, she went after her. She says to Mr. DeMerchant, "Wait until I get here." And she states, I'm going to go after her. So that's the objective evidence outside of this subjective belief. I need to protect this other person. There's separate evidence where this is a contentious situation, and she's also running after her, according to Mr. DeMerchant, and she's also stating to Mr. DeMerchant, I'm going to go after her.
Why is assaulting his partner a lesser harm than allowing her to assault someone else?
Your Honor, I would suggest that looking at the light most favorable to Mr. DeMerchant, he restrained Ms. DeMerchant so that she could not attack another person.
Well, I mean, putting his hands on her is still an assault, regardless of the extent of the assault. I understand there was different testimony on that.
Yes,
I mean, that's what he's really doing to raise competing harms as a justification for the assault. He's conceding the assault, isn't he?
He's conceding that there was physical contact, and then the ultimate, yes, Your Honor, he concedes that he made physical contact
Otherwise, you
with the
wouldn't be
jacket.
doing a justification.
Well, Your Honor, the jury then finds that it was offensive physical contact and an assault, but the jury was never able to consider whether Mr. DeMerchant was doing this in order to avoid a situation that was going to be worse than what he was doing by restraining his then wife. And so that's where the instruction was generated, and the jury in the defense should have been able to go to closing argument and argue that. They weren't able to, and instead the state's able to double down at closing argument and say there is no justification for what he did, that this is unlawful contact, and as long as you find it's offensive physical contact, then it garners a conviction. And so that's the issue here, is that the defense was never able to raise their theory of defense in closing argument or at trial generally.
We've said that the defendant must be threatened with imminent physical harm when viewed objectively, or another person must be threatened with imminent physical harm when viewed objectively for the competing harms defense. And the imminent use of non-deadly force is also required for defense of others. Is there any difference in the imminence, if you will?
I hadn't considered that question, Your Honor. I'm not sure if there is any difference. I'd have to look into that, but I don't want to speculate, Your Honor. So I'm not sure if there is a difference between the imminence component in 108 and 103.
Should we give any deference to the trial court's conclusion?
No, Your Honor. This court should review the record as it stands in the light most favorable to Mr. DeMerchant in order to assess whether or not competing harms defense was generated.
But the trial judge is there looking at the credibility of the witnesses, and isn't that the usual circumstance where we're giving some deference to the decision that the trial court is making?
Sometimes, Your Honor, yes, but in jury instructions, the jury is the one that's supposed to be making the important credibility determinations. This is about whether there's sufficient evidence for the jury to entertain a reasonable hypothesis that he could have been doing this in order to prevent a greater harm.
And we've given very little deference to the trial judge before in some of the justifications or defenses, such as in State versus Barr. Sorry.
Is the central issue here, is what really triggered this, the fact that the victim was very agitated and acting aggressively? Is that what is the tipping point here?
That, in addition to the statements that she makes about going after somebody.
And why was she so agitated?
Well, I'm not sure, Your Honor, and I don't want to
let me
speculate
suggest that she might be agitated because he gave her credit card to somebody else, and that's what wound her up.
Yes.
And as you know, the justification says when the person was reckless or criminally negligent in bringing about the circumstances requiring a choice of harms, they don't get it. Doesn't that fold the tent right there?
That is an argument that was not raised below at the trial court.
Yes, but if we're reviewing de novo.
But, Your Honor, I would suggest if you look at the record in the light most favorable to Mr. DeMerchant, then you'll also see Mr. DeMerchant talk about the reason, and Ms. DeMerchant about the reason why he had the card. They're married. He gets her debit card in order to buy her child, not his child, snacks.
And then gives it to someone else.
Well, Your Honor, what Mr. DeMerchant testifies about is that they run out of snacks, and he gives the card for somebody else to go buy more snacks. And so I appreciate she may be upset about that, but are we talking about culpability to the degree of criminal negligence or criminal recklessness that was uncharged conduct? I don't think subsection 2 applies. And again, I think this is a jury question and not a question for a trial judge to be making about whether the competing harms instruction was generated in the first place.
But isn't your fundamental problem that based upon the record in front of us, when you talk about imminence, we have no idea what the distance was really between Mr. DeMartin's wife and the victim and the woman who had the credit card?
Your Honor, I'm trying to remember whether the photographs were admitted in evidence because they do depict the scene. I'm not sure if they were, so I don't want to speculate.
They weren't.
But I would agree that the record is not as sharp as it could be on that point. But this was a situation in a parking lot where she ran after another person, and Mr. DeMerchant restrained her from being able to do so.
But you've seen those Hitchcock movies, though, where you're running down the hallway and it just keeps expanding.
And the trial judge kind of considers that. He says, well, who's faster? It doesn't matter. That's a question for the jury to decide because the defense has been generated. If there's no further questions,
I think there appear not to be, and it's about to turn red anyway.
Thank you, Your Honor.
Thank you. Attorney Hunter.
Yes. May it please the court, I'm prepared to take any questions the court might have.
The Chief asked earlier about the self-defense justification, whether it would or would not apply here. And I don't have the statute in front of me, but I think it's something like a person may use a reasonable degree of force to prevent what they reasonably believe to be the imminent use of force or something like that. As I recall giving the instruction, the word reasonably pops up maybe 2 or 3 times.
It does, but so self-defense wasn't generated. It doesn't work in this case.
I'm actually not going there.
Oh, okay.
My point is, in self-defense, the word reasonably appears frequently.
Yes.
But in this one, it says, in competing harms, it says, conduct that the person believes to be necessary to avoid imminent physical harm is justifiable. That almost suggests, as long as the person believes it, doesn't necessarily have to be reasonable. As long as they believe it, they have the justification of competing harms potentially available to them. Do you make anything of the fact that the word reasonable appears a couple times in self-defense but doesn't appear in competing harms?
I think it would be, I agree that it doesn't appear, but I think we should read it into it. If we're talking about a justification, I think it ought to have to be reasonable.
Well, we did. I mean, in State versus Neto, didn't we say that the defendant or another person must be threatened with imminent physical harm when viewed objectively, as well as a subjective belief that the conduct is necessary?
The case law recognizes an objective component, even though the word reasonable doesn't appear.
What's your view on whether our review of the court's decision that the issue was not generated, the issue of competing harms was not generated. Is that de novo, or is it abuse of discretion, or something else?
So the defendant moved that morning for the instruction, and we argued it, and the court addressed it to the extent, I want to say it's largely de novo. I mean, it's preserved issue. We're not in...
Don't we have to give, if it's de novo, and we have to give essentially all the benefit of the doubt on the facts to the defendant, who thought, oh my goodness, she's going to go, beat this other woman upside the head. Doesn't that generate the defense?
I don't think it does. I think the defense fails, the competing harm defense fails because of lack of evidence of imminence. So the evidence was he was going to prevent his wife
Well,
from...
but what does imminence mean? I mean, are we really getting into how far away is the other person?
Well, I think in this case, you would want so in this case, the wife, to at least have chosen to assault another person before she can be, assaulted to prevent it.
So you're saying it's not really a question, imminence isn't in this instance really a question of how far away the other person was or of the immediacy, but rather that there really was not sufficient evidence that there was actually going to be an assault even if she went after her.
Right. Several things had to happen before an assault would occur. She would have to choose to pursue the woman. I think there was some testimony. He said she was going after her, and he put his hand up. But she would have had to arrive at that woman and choose. And it's really not even an assault. It's more narrow than that. It's physical harm. So offensive physical contact wouldn't satisfy. I think the judge he didn't use the phrase restatement, but I think the way he characterized that in his instruction was, or during the argument, was the restatement version of physical harm.
So you're really looking at the language, for example, out of State versus Moore, which that in addition to the subjective belief, it has to be the evidence must demonstrate as a fact that physical harm was imminently threatened.
Yes,
and
yes.
So it's not just physical contact or that she was going to go grab her or something, but there has to be actual physical.
Right, or accost her or argue with her or threaten her.
Okay.
It would have to be physical harm.
So that sounds like what you're really saying is there wasn't enough to demonstrate as a fact that there was any physical harm to result aside from the imminence piece.
There isn't a good reason to conclude that Melissa was going to assault another, or was going to cause physical harm to another woman.
Regardless of the imminence, whether she was here or 50 feet away.
Right, and even her, her upsettedness was totally reasonable. So you can't be like, holy cow, this person is acting like a crazy person.
Can we consider that it was reasonable for her to be upset when we're considering whether a defense of a justification was generated?
Well, the defendant's version of what happened, right, was that he got her debit card to go do a particular thing.
Do we judge the credibility of what his version?
What's that?
I may not think that that's what happened, but do we, in our position, judge the credibility of what happened? Or if there is sufficient evidence, even if we think I wouldn't believe him, but there's sufficient to ask the jury, don't we have to say, then you instruct the jury?
I think if it's generated by the evidence, that's what our case law suggests.
Well, if we weigh the credibility of testimony, are we really viewing the evidence in a light most favorable to the defendant?
No, and you shouldn't. This court shouldn't be weighing the credibility of the witnesses. But if you accept as true the defendant's characterization of how this came about, that he got her debit card for a particular purpose. I'm going to say he used it for a different purpose. She was justifiably upset. There is another issue, and then we didn't argue this at the trial court, and we really didn't touch on it in the briefs. But the reason why self-defense doesn't work is if she had used physical force on this woman, it would have been lawful. So self-defense is only applicable to imminent.
You're talking about defense of a third person.
Yeah, imminent unlawful physical force. So it's weird to think that we're talking about these competing harms, and Melissa's lawful conduct is a harm in competition with the defendant's what would otherwise be a domestic violence assault. So that's why self-defense doesn't really work in this case, because there was no unlawful.
And it would be lawful because?
The woman had her debit card.
So you're allowed to assault people who have your credit card?
You would be allowed to use a reasonable degree of non-deadly force to get that card back.
Defensive property, is that what you're saying?
Yeah, she would have a defensive
But
property.
the defendant was saying he didn't think that she would limit herself to the lawful use of non-deadly force to retrieve the card.
That would satisfy the subjective component, but there's no other evidence about this particular, I'm going to call her Melissa, this particular person, that she would have gone too far or caused physical harm.
Well, the defendant testified that she said to him, and one of the reasons, in addition to jumping up and down, she's going to go after the woman with the card. I mean, now, she may have been legitimately upset that this woman had her card, but unfortunately in the news recently we've had a circumstance where somebody may have had a legitimate basis for being upset about something that happened to him and then went well beyond what is acceptable to society to try to resolve his upset.
Yep, but I think the physical harm that we're concerned about being imminent has to be specific. I think we need more than just
interpret go after someone.
Will go after her and get my card? It could go after her and.
Well, if we're looking at it in a light most favorable to the defendant.
I think to suggest that to go after her means assault her.
And cause physical harm.
Yeah, I do understand the court's point, but I don't think the evidence support it.
There don't seem to be additional questions. Thank you.
Thank you.
So what about that? If it wasn't unlawful, if she had gone after Tanika and used a reasonable degree of force, it wouldn't be unlawful at all. It would be, perfectly okay because Tanika had her property.
I respectfully disagree, Your Honor. Again, and I think when I'm hearing the back and forth, I think these are all good questions and dialogue that the jury should be having in the jury deliberation room because the competing harms defense was generated. Like in Netto, where the trial court allowed the competing harms defense, granted it's a bench trial, but the trial court actually considered competing harms defense and said that it didn't apply because the state disproved it beyond a reasonable doubt, which is what the state's burden should have been. And this isn't a case where somebody is upset with the healthcare industry and is going out of their way to try and right a wrong because in his subjective belief, he believes something else is that's a greater harm. This is a situation where a person is in the heat of the moment in a contentious situation, making a decision to restrain somebody to prevent a greater harm between two other people. And I think if you make people follow the other person and wait until they're close enough, that just cuts away at the competing harms defense and really.
Well, I think that what I was getting from Attorney Hunter's argument was not. The imminence is important, but it's really not dependent on how far away the person is. It had to do with physical harm as well. In other words, there has to be imminent, that physical harm, not just an assault, not just grabbing somebody, not just give me my card back, but that there has to be specificity to show to the defendant that physical harm was imminently threatened and that's what's missing.
And I think it's here, Your Honor, looking at the record in the light most favorable to Mr. DeMerchant, that Ms. DeMerchant testified she was angry, told him that she would wait until she gets here, I'm going to go after her, and then in fact ran after her, causing him to restrain her.
But
so
going after somebody to get your card back isn't a harm, is it? I mean, she could have. Where is the evidence that she was going to use more force than she would be allowed to under the law?
Your Honor, I think looking at the light, in the record in the light most favorable to Mr. DeMerchant, she wasn't going, I don't think the court can find that she was going there to quickly snatch the card out of her hand. She was saying, wait until she gets here, and she testified she's angry. I'm going to go after her doesn't mean I'm going to get my card back. It means I'm going to go after that person, and then to run after a person is not how people of, looking at ordinary standards of reasonableness go to approach somebody to get a card back. That's somebody who's going to attack somebody. Again, this is all about a generation issue. These are all fair questions for the jury to have in the deliberation room, and for those reasons we ask the court to vacate the decision for a new trial.
Thank you.
Thank you, Your Honor.
Thank you, counsel, for the argument, as is our usual. practice, we will take the matter under advisement and issue a written decision in due course.